rise. The Court of Appeals Division 1 is now in session.
Thank you. Please be seated. This is the time set for oral argument in 1 CR23-0163, State of Arizona versus Pablo Javier Castillo Islas. As a reminder, this hearing is being video and audio recorded. The recording will be posted to the court's YouTube channel in a few days. Counsel, before you begin your argument, please identify yourself and the party you represent. Each side will have 20 minutes. If the appellant's counsel would like to reserve time for rebuttal, you're free to do that, but you're responsible for keeping track of your own time. We have read the briefs and conferenced the case. We're familiar with the issues, so there's no need to repeat what's in your briefing. So, counsel.
Thank you. May it please the court. My name is Chad Winger. I represent the appellant in this case, Pablo Javier Castillo Islas. Good morning, Your Honors. This court may not deviate from the controlling decisions of the Arizona Supreme Court. And although one may question the rationale and the wisdom of the blanket rules set forth in cases such as Holland and Kunzler, we are not free to depart from them. What is clear from cases such as McNutt, Holland, and Kunzler is that unexplained and unjustified denial of counsel deprives a defendant of fair trial. The right to counsel is an extension. It's an extension of the right to gather exculpatory evidence. It is our contention that the invocation of the right to counsel is an invocation of the right to gather exculpatory evidence. And as is stated, because we value the right to counsel so highly, when the right to counsel is violated, then the conviction must be set aside. It is the rule because it is impossible to foresee what advice would have been given to the defendant.
Counsel, let me jump in here, and let's come back and talk about Holland in just a second. But before we do that, can I make sure we understand the timeline of what happened? So first we have your client being, he was off to the side of the road, police come in contact with him, they do some field sobriety tests, they place him under arrest and Mirandize him there, correct?
Correct.
He's transported to Prescott Valley Police Department, is that right?
That's correct.
There's a failed breath test, then there's a successful 2 breath tests, and he signs the independent breath test advisory form at Prescott Valley Police Department. Is that correct?
That's correct. Those are the findings of the trial court.
Okay. Then he's transported to Prescott Police Department, correct?
Correct.
And that's where he's told, we're going to have this phlebotomist draw your blood, to which he responds something to the effect of, no one's touching my blood, I want an attorney. Is that correct?
That is accurate. Those are the findings of the trial court.
And then at some point, maybe 3.5, 4 hours after the arrest, he's transported to the Yavapai County Jail. Is that right?
I'm not sure about the number of hours.
It was after the 2 hours. It was post 2 hours from the arrest, correct? Or post 2 hours from driving. And he was never afforded an opportunity to talk to an attorney before he got to the Yavapai County Jail. Is that right?
That's correct.
Okay. Let's talk about Holland for a second.
Okay.
So, in your view, does Holland essentially say, if your right to counsel is violated, case is dismissed?
In most cases.
Okay, when would a case not be dismissed?
Certainly.
Under Holland, when a right to counsel is violated?
Certainly. I think the short answer to the question, Your Honor, is that a case would not be dismissed if, in fact, something happened in the circumstances of the investigation where exculpatory evidence actually was gathered and was available to the defendant at the time of trial. I think 2 cases in the briefs stand for this proposition. The Keone case and the Rosengren case stand for that proposition. There was a violation of the right to counsel, but in both of those cases, the defendant or the suspect was driven to a hospital. In Keone, at the request of the suspect. In Rosengren, it was part of the investigation that he was taken to the hospital. Those are the only 2 cases in the briefs where the suspect was, where they said right to counsel was violated. However, it did not violate the right to gather exculpatory evidence. The reason being is that the exculpatory evidence existed because they were at the hospital. There were people to observe their demeanor, how they spoke. There was some chemical testing, blood testing that was available for independent testing. And I know.
Let me jump in on Keone. So factually, something that's different here than Keone. Tell me if I'm correct here. Keone specifically said, "I want an independent breath test." Correct?
Correct.
He invoked right when he was pulled over. Police denied it. 30 to 35 minutes later, after they did the breath test, they personally drove him to the hospital to let him get the breath test. But factually, that's a distinction, correct, in Keone? Defendant specifically asked for an independent breath test there, but your client did not. Is that fair?
That is correct. My client did not ask for an independent blood test. I think the record is clear that he did sign the independent test advisory form. But what I would say in response to that, Your Honor, is that I don't think that there's anything in the case law that conditions dismissal of a case on a defendant or a suspect's invocation of the right to an independent test. The right to an independent test is a statutory right that's given to defendants. And I think something that was interesting in preparing for this oral argument is when I mapped the cases, the pattern that I saw in my friend's brief from the state is that all of the cases where they argue that this assertion of the right to an independent test must be made in order to preserve the right to gather exculpatory evidence, every single one of those cases cited in that portion of the brief is not a right to counsel case. All of those cases are cases where it's a case solely about did they violate the right to gather exculpatory evidence. None of those suspects or defendants invoke the right to counsel in those cases. And so when you look at cases like the Van Herwig case, when you look at Amos versus Bowen, when you look at Juarez, Kemp, Gansky, none of those cases are right to counsel cases. Those are cases where the court talks about whether due process was violated simply because whether someone was able to get that independent test, and if they were not, then they were deprived of the right to gather exculpatory evidence. It's our contention, and I think that the Arizona case law needs to have a bright line rule, because if you do go back to the cases of Holland, McNutt, and those cases, I think what is clear in those cases is that if one invokes the right to counsel, that's an extension of their right to gather exculpatory evidence. And if you deprive them of the right to counsel, you are necessarily depriving them of the right to gather exculpatory evidence.
So, counsel, can I just clarify something? You relied on Rosengren, but doesn't Rosengren say that the remedy for denying the right to counsel is suppression of evidence obtained after the violation?
In regards to the Rosengren case, I apologize, Your Honor. I believe that Rosengren is somewhat of a unique case, and I think that it's silent as to why it wasn't a violation of the right to gather exculpatory evidence. I don't think that Rosengren necessarily says that. Also, I think the important part of Rosengren is the sole charge in Rosengren was manslaughter. And the court said in Rosengren that intoxication is not a necessary element of a manslaughter charge. And so therefore, all these special narrow exceptions to the right to counsel and law enforcement's obligations to respect the right to counsel, I think that really those were not applicable in that case because the intoxication was not a necessary. This case, Mr. Castillo Islas was found guilty only of DUI above .08. That was the sole thing that he was found guilty of. And certainly intoxication is a necessary element of that charge. So I would say that there's a distinction between Mr. Castillo Islas' case and the Rosengren case.
So I'm sorry, go ahead.
Sorry, could I ask you about Kunzler? The Kunzler remedy suggested by the Arizona Supreme Court, and it's a case that postdates Holland. In Kunzler, the Supreme Court says that if they say he was denied his right to consult with an attorney, and they send it back saying if he could have been afforded the right if he could have consulted with an attorney without interfering with the investigation, then the remedy is to suppress any evidence obtained after the denial of the right to counsel. So why doesn't that apply here?
I can't remember if this is exactly accurate, but well, first off, in Kunzler, there's a distinction between Kunzler and Mr. Castillo Islas' case, and that is that Kunzler was released 70 minutes after his arrest. And so although it's not expressly stated in the case, I guess my presumption is that because he was released, he had the opportunity to gather exculpatory evidence. He had the opportunity to gather exculpatory evidence while it existed.
But here your client also had the opportunity. He was told by police officers that he had the opportunity to do it. The argument seems to be, well, I didn't want it, but maybe the attorney would have told me to do it. But he certainly wasn't, he didn't make a request and then have that request denied. And he was in fact told that he had the right to have some independent testing. So it seems weird. I'm having a hard time getting past the language in both Kunzler and then also in Juarez, where the discussion is if there's a denial, and those are both Arizona Supreme Court cases that post-date Holland, and the discussion seems to be if there's a denial of the right, we suppress anything that was obtained after the denial of that right. Am I misreading Kunzler and Juarez?
Well, I think that, again, my contention not regarding Kunzler is Kunzler was released. Mr. Castillo Islas was not. Also in Juarez, I don't believe in Juarez anyone invoked. Let me just look at my notes on that. In Juarez, they did not invoke. They were given an opportunity to make a telephone call. There were three defendants in the Juarez case. They were given access to a telephone. They chose to call friends or family members instead of an attorney, and I don't believe that there was an invocation in Juarez. In Kunzler, there was an invocation, but what I would say the distinction is in Kunzler is that Kunzler was released. Kunzler was able to gather exculpatory evidence, unlike Castillo Islas, who was...
How is Castillo Islas not allowed to? He was told he was given the form. He could have. The same thing would have come up in Kunzler, assuming he's released, but he's not talking to counsel. He has an opportunity to do it. It seems like your client has that same opportunity when the police is giving him a form and telling him you will do that.
Well, and I guess I go back to the language of Holland, as I stated in my brief, and that language is...
But why doesn't that compel dismissal in every case when there's a denial of counsel?
Well, because if there are situations where someone has the opportunity to gather exculpatory evidence, and again, like in the Keone case and the Rosengren case, when they're taken to the hospital, there's available exculpatory evidence. In Kunzler, when he's released after a 70-minute investigation...
And here he was taken, they said, we'll draw blood, and he said, no one's touching my blood. But so they were there. There would have been, to the extent it was exculpatory, but he wasn't denied the chance to obtain it, is where I'm struggling with this.
Well, but he was denied the chance to consult with counsel. It's our contention that the right to counsel in a DUI investigation is an extension of the right to gather exculpatory evidence, and the state cannot, without explanation, in an inexplicable manner, deprive him of the opportunity to speak to counsel. Any competent counsel who was contacted, it would be malpractice if they didn't tell a DUI suspect to gather exculpatory evidence. And the state can't deny him the opportunity to speak with counsel who case law says it's presumed would advise him to gather exculpatory evidence.
Can I give you a hypothetical? How about if the police officer says, the intoxilizer was pretty close, it's borderline, there's a chance that if you have blood work done, maybe it'll be more favorable to you. If they'd gone through and actually explained everything, is it still a per se dismissal of the charges? If they go through and say there's a chance that if you get your own breathalyzer, it might be different, it might be more favorable to you. There's a chance if you have a blood draw, it might be more favorable to you. Do you want to do that? independent of them saying, no, we're not going to get you counsel right now. Is it still a per se dismissal of the charges?
I would never say that it's a per se dismissal of the charges. What I would say is that if you're deprived of the right of counsel and then you are jailed, and by the time you're released, you no longer have the opportunity to gather your exculpatory evidence that is now dissipated. That's very important to your DUI defense. I would say it's a dismissal. Of course, it's not per se. I mean, there's cases that there's not a per se dismissal. Keone's an example. Rosengren's an example. But and I do want to talk about the statement, no one's touching my blood. I think if you look at the cases cited in the briefs, you look at, I would say that was a refusal of law enforcement's invitation for him to allow them to take his blood. But if you look at Juarez refused, Sanders refused, Rosengren refused, Penny refused, Kunzler refused, Transon refused, and in Rumsey, they did allow testing. But in all those cases, the analysis does not go into whether a refusal has anything to do with your right to gather exculpatory evidence. They mention it as part of the facts of the case, but they never analyze a refusal as somehow being a way that you waive your right to gather exculpatory evidence.
You would agree there is a difference, though, in a case where the defendant, I think it's McNutt, says, I would like an independent sample, and I want to talk to an attorney, and the state doesn't honor that request. Is different than a case where the state says you have a right to an independent sample.
But it's not requested.
And then it's not requested. That seems like a very fundamental, because I completely understand the point that if you interfere with someone's ability to do something, that seems different than saying, I gave you the opportunity, you said no, but if you had talked to an attorney, the attorney might have persuaded you. That doesn't seem like I'm necessarily interfering with your opportunity. It's just an attorney might have persuaded you to do something different.
Well, I think the deprivation of that advice is a deprivation of your right to gather exculpatory evidence.
But so why don't they say that in Kunzler and Juarez? Why don't they just say if you could have consulted with an attorney without interfering with the investigation, we're going to dismiss the charges? Why do they say we're going to suppress evidence obtained after that?
Well, again, I would go back to my 2 points about Juarez. In Juarez, no one invoked, and in
but they did in Kunzler.
They did in Kunzler, but also in Kunzler, again, I think it's the opinion is silent in terms of why suppression as opposed to dismissal. I guess the presumption is, the fact in Kunzler is that the defendant was released, was not jailed, and was not released only after the evidence had dissipated. I think that's the key distinction in this case between Kunzler and Castillo Islas' case. I reserve, unless there are any other questions, I reserve the remainder for rebuttal. Thank you.
Thank you.
May it please the court, Eliza Ibarra for the state. Dismissal is an extreme remedy that totally immunizes the defendant from liability for criminal conduct. Although it's occasionally an appropriate remedy, here it would be a windfall because the deprivation of timely access to counsel did not interfere with the defendant's ability to obtain an independent blood sample.
So counsel, the state concedes the defendant's right to counsel was violated, correct?
I think in the brief I said, assuming arguendo, that it was because I couldn't find any evidence in the record.
Tell us how the defendant's right to counsel was not violated. What argument is there that his right to counsel was not violated? He asked for an attorney after the breath tests were administered and they had successful results. He asked for an attorney. They never let him talk to an attorney. There's no argument, I don't think, being made that it would have impaired or hindered the investigation or delayed the investigation, correct?
Okay, well, so the defendant did testify that he invoked counsel after the breath test in Prescott Valley, but I think the court found that not credible when it went through the analysis. And if you look at the trial court's ruling, the trial court actually says that it finds that, I don't want to misquote it, but it basically says, let's see, under the facts of this case, the court finds that the defendant's right to counsel was not violated, nor was his right to collect exculpatory evidence. And at first I thought this was strange because I didn't see any evidence of counsel, but then I probably reread the transcript about 25 times. And as I was reading it the most recent time, I noticed I had originally thought that the defendant actually testified at the evidentiary hearing. I was never provided access to a lawyer. But he didn't actually say that. If you go back and look, what he said was, in Prescott Valley, I was not provided access to a lawyer, or I wasn't given the opportunity to call a lawyer, something like that. And then defense counsel asked him, well, what about at Prescott and Prescott Police Department? And he said, I wasn't provided access, or however they phrase it, there either. And then they never say anything about the Yavapai County Jail, which we know is just minutes away from the Prescott Police Department.
But there's no dispute he said, I want a lawyer.
Correct.
And there's no dispute he was not given access to a lawyer, is there?
I think what there's no dispute about is that the record doesn't show that he was given access to a lawyer. I think we just don't know what actually happened, if that makes sense.
I read your brief as suggesting that if we were to agree with the defendant's position, there would be a need to remand to find out when if he in fact consulted with someone. Is that what you're saying?
That was what I said in the brief. I think I'm assuming based on the questions that the court has asked that the court is already aware that my understanding of the timeline was wrong when I wrote the brief. And you've received my notice.
Do we know for certain that he did not have access to counsel within the 2-hour window?
Oh, I see what you're asking. Actually, I don't think there's a dispute about that because he was pulled over at 2:11. And then when you total up all the times, and now that I know that he signed the form at Prescott Valley Police Department at 3:51, and then it took at least 20 minutes to get to Prescott Police Department, that 2-hour period had to have been over by the time he invoked counsel, and he was not provided a lawyer before that.
And I'm not positive of the exact. Is that the maximum amount of time that you can have an additional testing done? And as a follow-up, do we know that an attorney could have been provided within that time frame, given being moved to different locations?
I guess I haven't thought about that because I think it's clear from the record that he didn't say I want a lawyer until he got to Prescott Police Department. So I've thought about going forward from then. I don't know. I guess there's not really a lot of evidence or discussion in the record about whether he could have been provided access to counsel in Prescott Valley Police Department. I think there is testimony that he was sleeping, so I guess theoretically if he had invoked, they probably could have given him access there.
But I'm just a little bit confused by the timeline. When he says, I would like an attorney, how much time is there left to do from that point to do some independent testing where it would still yield
I see what
results?
you're asking. Well, I guess the answer really depends on how long you can still have a valid test. If it's 2 hours, which I think is what the case law suggests, then I think it had already passed by then, at the time that he invoked.
So by the time he had invoked, okay.
Yes.
What time did he invoke?
We don't know for sure, but we know that the form that he was given at Prescott Valley was signed at 3:51. So he was pulled over at 2:11. And then there's also testimony that it took 20 minutes to get to. So that would be, this is why I'm a lawyer, I'm not super great at math.
It would be 4:11?
Yes. And so for sure, I mean, and that's not accounting for any time for getting him out of the car and sitting him in the chair and anything like that. So at least 2 hours would have had to have passed.
Well, is that the basis for the Superior Court saying your right to counsel was not denied, or what?
It's not totally clear from the record, but I think that the court could infer that that was the basis.
It's just-
But the right to counsel doesn't go away at a magic 2-hour mark. You would agree with that, right?
Definitely.
It's just that the nature of gathering exculpatory evidence it dissipates. Time is
Right.
of the essence. But the right to counsel doesn't go away after 2 hours.
Oh, definitely not. I think the real issue in this case is whether the defendant's act of being advised of the independent advisory form and saying that he understood it and saying that he signed it, and then when you look at the form itself, sorry, let me back up. The real question is, did he say, I don't want independent testing? And I think if you look at the totality of the facts and circumstances here, it's really clear that he did.
Okay, hold on. Does a defendant or a suspect have to affirmatively indicate that they want an independent breath test? Or do they have to say they don't want an independent breath test? Is it assumed that they want one if they sign the advisory?
If the record is totally silent and they invoke counsel, I think you presume that dismissal is appropriate because of the possibility that they silently wanted one.
Because of Holland? Because
I
Holland...
guess that's the original case that seems to have started the trend, but I think that more recent cases have taken into account the individual facts and circumstances of the specific case, like Rosengren, Keone, Penny. They all consider what actually happened here. I see. Did you have another question?
Go ahead.
Okay.
I'm still just a little bit confused. You're saying it's already 2 hours before he invokes his right to counsel?
Yes.
And because the discussion, I think, in Kunzler is, yeah, we have to you need to provide an attorney if you can do it without interfering with the investigation. So there's a recognition that it's not necessarily going to be something immediate, but if you can do it without interfering with the investigation, you need to do it. But the point I'm trying to make is what use is it to the defendant if by the time he's asked for an attorney, it's already too late to do independent testing? So I'm not sure I'm following the defense argument that it's that the denial of that right now has some bearing on what would have happened, because assuming he talks to counsel at that point, it's too late to get an independent test. So that hasn't changed whether he's been impeded in obtaining exculpatory information. Sorry, that's not much of a question.
No, I think that's correct. I think you said it much more articulately than I tried to.
Can't you retrograde? Can't you get an expert to? Can't you retrograde and test something after 2 hours?
I'm not 100% sure because I'm not an expert in this, but I would defer to the court's knowledge about that. If the court, obviously,
I don't think any of us have any knowledge of it.
Okay. Did you have another question?
Go ahead.
Okay. So I was thinking that perhaps the Miranda context is analogous here. When we read the Miranda rights to suspects, we don't require them to specifically say, I am waiving my Miranda rights. You look at the totality of the facts and circumstances to determine whether you think that happened. And if you look at the record,
But doesn't someone have to affirmatively say, once their Miranda rights are read to them, don't they have to affirmatively say, I want to talk to an attorney? They have to affirmatively request it, correct?
I mean, if they want a lawyer, yes.
Right.
But they can continue
thank
to...
you.
to-
So
okay.
this is back to my question on the independent breath test. Would someone have to affirmatively ask to have an independent breath test once they're advised of that right?
Oh, I see what you're asking. I don't know that the case law has clearly decided that. It does seem strange
Is that an issue in this case, do you think? Do you think that's something we need to, that question impacts the outcome of this case?
I don't think it's dispositive here because I don't think it matters, but I think it could be an additional reason to affirm, if that makes sense. I think it's strange that there is this independent testing advisory form if there isn't some kind of affirmative duty on the defendant to invoke it, but I do think that perhaps some cases suggest that asking for a lawyer would sort of implicitly, if the record is otherwise silent, would implicitly include the possibility that a lawyer might advise them to get tests. But I don't know that I've seen a case that squarely reached that.
Holland seems to imply we're going to speculate that what the attorney would have advised, and they would have advised them to get an independent breath test, even though they didn't ask for it. That's what Holland seems to imply, unless I'm misreading it. So tell me if I'm misreading it.
Well, I wouldn't say that, but I do think that the facts of Holland are really interesting. In Holland, the defendant actually was given access to a phone and was on the phone with counsel. So I think you can read Holland as more about the right to privacy, because there wasn't, the police didn't allow him to speak in private with his counsel, and so that kind of limited the counsel's ability to tell him what to do.
But it's a denial of counsel, and they're saying it seems like it's the same denial if we just don't get you an attorney at all. You've been denied counsel. I agree that it seems very egregious to want to be listening in. But if we're just talking about its denial of counsel, whether it's denial of counsel being able to talk freely or not having counsel at all, it still seems, it's hard to distinguish it on that basis.
Well, I think that you have subsequent cases that do a really great job. You have Keone, Penny, and Rosengren all saying that it depends on the facts and circumstances of the case, and Rosengren and Keone say that suppression is an adequate remedy. And in most contexts, when you decide whether dismissal is an appropriate remedy, there's some type of bad faith on the part of the police. And here, I just really don't see anything like that. Like, I mean, either the police went ahead and got a warrant and drew their blood, and then tried to use a counsel after denying them counsel, after not providing the opportunity to call. Like, I think that's what happened in Rosengren. And even there, it was suppression that was sufficient of a remedy to deal with any issue with the right to counsel. So I think that Holland started out as a fairly all-encompassing statement, but I think subsequent case law has made it clear. I think also the cases that the court mentioned.
Well, Kunzler, they do say the remedy would be suppression of evidence obtained after, but in Kunzler, the defendant does ask for an attorney before the breathalyzer test. So if it goes back, they wouldn't have any testing done in Kunzler, I think is what I would argue if I'm the defendant. So although they say it's just suppressing the evidence, it might be a de facto dismissal if that's the only evidence.
Well, there really does, I think, have to be a nexus between the harm that's alleged. I don't think you can say, it just becomes very remote if you take this long speculative argument that, well, the defendant didn't want the blood testing, but it's possible that maybe if he'd been given access to counsel might have talked him out of it. And
I mean, isn't that exactly what Holland holds, though? It seems like it's just based entirely on speculation.
I think if it were that black and white, then Keone and Rosengren and Penny couldn't have come out the way that they did. I did think of one potential analogy that was useful to me that I'd like to share with the court, if that's okay. If you imagine that a body was found at the home of a defendant, and the defendant had a security system that ran on a loop for every 2 hours, and if you download it, then you can save it, but otherwise it automatically gets deleted. And then so police come and they see the security system, and they know that the defendant was home during this time, and they say, well, we see you have this security system, you might want to download it to prove that you're innocent. And the defendant, who totally knows what he was doing in this home and how his security system works, says, no, thank you, I want a lawyer. And then later on, because he's not immediately given access to a lawyer, in an ordinary course of events, the footage is deleted, and he later argues, well, if I would have been timely provided access to counsel, immediately then, counsel could have told me to download the footage because it might have been exculpatory, and I'm entitled to total dismissal of the case. That just seems like a really extreme remedy for no specific harm, because the defendant was fully aware of what he wanted. And I think it's analogous here because no one knew better than the defendant how much he had drunk and what what further blood testing would show. He had just been advised of the right to independent testing, and he admitted that he understood it, and he signed the form saying he understood it, and Officer Hegstead went over the form with him and confirmed that he understood it and didn't have any questions, and he never asked for counsel when he signed the form. And so dismissal just becomes this really extreme remedy that's too black and white, and it's not appropriate here. Here, suppression is appropriate. But because the state honored his refusal to take the blood sample, there's nothing to suppress. But the state didn't use anything at trial after he invoked counsel. It was all the breathalyzer tests that he consented to well in advance of invoking counsel, and the field sobriety tests, and then the police officer's testimony. So there's just no bad faith, and there's no specific harm, and I think the remedy is not as black and white as he would suggest, and you don't have to take my word for it.
Bad faith isn't. Does bad faith have anything to do with our analysis?
I think if you look at footnote 5 in Rosengren, they're talking about when is dismissal appropriate versus when is suppression appropriate. And they say that dismissal is appropriate when you interfere with the defendant's ability to have a fair trial. And they cite the U.S. Supreme Court Morrison footnote 2 to that case. And Morrison talks about how dismissal is a pretty extreme remedy. Usually you have to have either bad faith or an interference with the defendant's ability to obtain a fair trial. So it's sort of part of the same thing. I'm not suggesting if you don't find bad faith, then you can't have that remedy. But I do think they're both factors that would enter into the analysis. And here, there wasn't interference with a fair trial, and there also wasn't interference, there wasn't any sort of bad faith that I can see. As far as the police officers knew, they were taking him to a place where he would be automatically appointed counsel at the Yavapai County Jail, and we don't actually know if that happened or not. But what we do know is that nothing was used after he invoked counsel to convict him.
It's hard for me to think the officers were doing something noble by transporting him to the county jail and inferring that, he'll get an attorney there. He asked for an attorney, they didn't give him one. Seems pretty clear there was a violation at that point. It's hard for me to give the state much credit for then transporting him to the jail like they were doing something noble and affording him a right to counsel.
I don't mean to imply that they were doing something noble. What I do think is fair to say, since the jail was literally a minute away, and I think that he admits this in his testimony at the hearing, I think that there isn't a sign of bad faith or an attempt to interfere with his right to counsel, like you might find in other cases where the defendants, I'm sorry, I see my time is up. If the court has no further questions.
All right, thank you, counsel.
Thank you.
Mr. Weir?
Thank you, Your Honors. I think we've kind of narrowed the concept of exculpatory evidence in a DUI investigation. We've spent all of our time talking about the independent test advisory and being able to get a blood test. Is it within 2 hours? I mean, the case law recognizes that there is myriad exculpatory evidence that could be gathered just beyond chemical testing. And in answer to the court's question, I believe that certainly even if you were to get a blood test after 2 hours, retrograde science is used every day.
Do you know how long how long you can wait and still use retrograde?
I don't know how long, but I know that retrograde is used all of the time.
Yeah.
But I certainly think in this case, retrograde would be effective within the timeline that we're speaking of. I also want to note that, look, under the rules of criminal procedure, someone is appointed an attorney at their arraignment. So in terms of him going to the being booked into jail and having an attorney at that point, that's not realistic. An attorney wouldn't be appointed at that time.
Is there an affirmative duty to say you want an independent breath test?
No, I do not think that would be. There's nothing in the case law that says that you have to affirmatively request a breath test, or request an independent test. And again, I go back to, if you look at the pattern in the case law cited for this proposition in the state's briefs, every single one of those cases is not an invocation, a right to counsel case. That was not an issue in that case. The case was solely, you were advised, and did you or did you not ask for a test, and based on the circumstances, were you deprived of the right to gather exculpatory evidence? They are exclusively exculpatory evidence cases. They have nothing to do with the right to counsel. So I think the question in this case is, do we take seriously what Transon says, that the right to counsel is an extension of the right to gather exculpatory evidence? Our contention is that Holland stands for that proposition. If suppression is the appropriate remedy here, it just doesn't make any sense how law enforcement can blatantly deprive someone of their right to counsel. And the last thing I'd like to say is, if you look at the court's ruling in this case, it's terribly confusing. It starts out by asserting that the proper remedy for...
Counsel, your time is up.
Thank you.
All right. Thank you. Thank you for your presentations. We'll take this under advisement, issue our decision in due course. We're adjourned.